All right, the next case to come before the court is State of Ohio versus Christopher Goins. Each party will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. Mr. Brown, if you intend to reserve rebuttal time, just let me know. I will do my best to monitor it for you. The arguments are being visually and audibly recorded to be posted online, so please keep your voice up, remain behind the podium. You should not use the names of any children. That has nothing to do with this case. So we've read your briefs, and we are ready to proceed when you are.
Okay, thank you. Your Honor, I'd like to reserve 3 minutes of rebuttal if I can.
All right.
Thank you. May it please the court, I'm Pat Brown. I represent the appellant, Christopher Goins, in this matter, and this appeal raises two distinct issues. One we could call purely a legal issue. The second is, a mixed question of law and fact. The first issue being under Mommy v. Wisner, did the state meet its burden in this case of establishing the facts precipitating the dispatch that led to the stop of Mr. Goins' vehicle? Here, the state played a recording, which was admitted as State's Exhibit A, between a citizen and an identified dispatcher, neither of whom were called to testify at the hearing. No records custodian was called to testify at the hearing, and that State's Exhibit A was admitted over the objection of defense counsel. It's the question for this court on the first issue is, number one, was it proper to admit that recording? Number two, is that sufficient to meet the state's burden to establish the facts precipitating dispatch under Mommy v. Wisner? Now, when I filed my brief and the state filed its brief, neither of us cited this case, State v. Edwards. In the meantime, before I filed my reply brief, I found that case, State v. Edwards, the Ohio Supreme Court case from 2005. I felt I had a duty to bring it to the attention of this court. And now it's my duty to try to distinguish it. And that case touched on authentication of evidence in suppression hearings.
I'm going to stop you on Edwards in the sense that if you didn't ask it to be supplemented, we're not going to hear arguments on it today, but suffice it to say, I'm sure our research will lead to it.
Well, Edwards is in my reply brief.
I apologize. I misunderstood what you had to
No,
say.
I'm sorry. What I was saying, Your Honor, is that I didn't put it in my initial brief and the state had cited. I found the case and did put it in the reply brief.
Thank you.
And Edwards touches on authentication of evidence in suppression hearings. Now, that case dealt with a very different issue. That case dealt with whether the state had met its burden to prove that a breathalyzer was calibrated in compliance with the Ohio Administrative Code. And to do so, in that case, the state introduced a photocopy of a certificate from the Director of Health regarding the alcohol solution in the breath machine, and had the trooper testify that the photocopy was a true and accurate copy of what was back at the post. The Supreme Court in that case seemed to imply, they certainly said the rules of evidence don't strictly apply in suppression hearings. I'm not disputing that. If read at its broadest, I guess you could read that case for the proposition that evidence need not be authenticated at all in suppression hearings. Now, I have a hard time believing that's what the Supreme Court meant by those words. And again, that case dealt with a very different issue from this case. In that case, they're dealing with a photocopy of a solution certificate. In this case, we're dealing with a recorded call, and the state didn't call either party to the call and didn't call the records custodian for the call, did nothing at all to authenticate the call. I would submit that the state has to do something to provide some level of assurance to the trial court that the call is authentic. And if you look at the standard of review for these kind of cases, factual findings need to be supported by competent, credible evidence. In order for those words to have meaning, I would submit, that implies some kind of authentication is necessary. Whether the rules of evidence strictly apply or not, and the Supreme Court has said they don't, I would submit that the state has to do something, provide some level of assurance to the trial court that the evidence is what they say it is. In this case, they did nothing. So I would submit that the state's Exhibit A was improperly admitted. I believe the state in this case either had to call a party to the call or at least call a records custodian to talk about state's Exhibit A. They did none of those three.
As I recall, the person that testified was the dispatcher for the Ohio State Patrol.
That's correct, Your Honor.
Okay. And the 911 call came into the Wayne County Sheriff's Department?
That's correct. So there was kind of a chain of events. And the the state did call the dispatcher for the highway patrol, but he testified that he has no familiarity with the Wayne County Sheriff's Office records retention system, and I think the state concedes as much in its brief that he wasn't an appropriate person to testify about that call.
So that dispatcher would have received a notice either via computer or a call that said that they had received this 911 call from whoever, and they would have just dispatched, you know, that there's a car that the make and model of the Ford or whatever, you know, the truck. And so it's not like they played the 911 call either. So the first dispatcher from Wayne County just relayed that they received a 911 call about a drunk driver.
That's correct. The dispatcher from the Wayne County Sheriff's Office called the highway patrol, and that call is actually admitted into evidence as Defense Exhibit 3. And all the sheriff dispatchers unidentified told the highway patrol is that be on the lookout for a green, and it's right there, be on the lookout for a green Ford truck and a possible .19, referring to the 4511.19. No other facts were provided. License plate, description of driver, model of the truck, shade of green. All the sheriff's office told the highway patrol is be on the lookout for a green Ford truck heading towards the city of Worcester from the O'Connell Lodge.
That's what I thought I read, but then I also thought I read that the Ohio State Patrol officer that pulled your client over actually verified the license plate number before he pulled him over.
Well, he certainly verified it after he pulled him over, obviously, but there was a big dispute because there was a lot of confusion in the record, and I think that was resolved. I had filed a motion to compel if there was some other call, because the only information based on what was admitted at the hearing was that the highway patrol knew they were looking for a green Ford truck. There was no other call with the license plate number. So there would have been no way for the trooper to know what the license plate number was unless there was some other information. The state actually went back to look to see if there was another call. At first, I should say that in the transcript, the Ohio State Highway Patrol dispatcher admitted on page 13 of the suppression transcript that the call between him and the sheriff's office that was played at the hearing was the only call he had with him that night. And that didn't include the license plate. But the state, to follow up on this, the prosecutor actually followed up with the Highway Patrol and the sheriff's office. And if you look at the transcript from September 5th, 2018 at the plea hearing, the prosecutor confirms that that call that was played at the hearing was the only call. They went back and they looked to see if there was any further information. So I think we can conclude with absolute certainty that the trooper did not have the license plate at the time he stopped Mr. Goins. That's clear from the record. Okay. So that leads into the second issue in this case, even assuming, for the sake of argument, which I do not concede, that the state established the facts precipitating dispatch. Did the trooper have sufficient information to stop Mr. Goins? In other words, did he have sufficient information that the vehicle that he stopped was the vehicle that he was looking for? If you look at the dash cam video in this case, Defense Exhibit 1, and the trooper's testimony, he stopped Mr. Goins' vehicle at most 2 seconds after it came into his view. If you look at the trial court's entry, it was a dark, rainy night. It was about 1:30 in the morning. I have my doubts about whether the trooper could even tell that it was a green truck. And again, the only information he had at that point is he's looking for a green Ford truck. I have my doubts about whether he could tell it was a Ford truck. He certainly didn't have the license plate. I would submit that he did not have sufficient information to stop that vehicle. He's looking for a green Ford truck somewhere in the city of Worcester.
Well, he knew it was near the O'Connell Lodge. He did find
He knew
it
it
says
was,
a minute and 30 seconds away. Is that not true?
well, he knew it was leaving from the O'Connell Lodge, but there's about 30 different routes you can take around that area. There's a lot of highways and bypasses. And the point at which he stopped Mr. Goins is probably about 2 miles from the O'Connell Lodge. Could have been anyone. Now, obviously, it ended up being Mr. Goins. That's why we have a case, but that's not what we look at. We look at the information the trooper had at the time and whether that was sufficient. So the information he had is clear from the record. All he had is he's looking for a green Ford truck.
Counsel, I get confused with these cases, so hopefully you can enlighten me.
Okay.
Because,
this is a confusing one.
well, just not this, but in these type of cases, because obviously this was not an anonymous call.
It was not.
There's a citizen informant that indicated his name and so forth. And I think the case law provides, but it's not usually like this. There's usually more information maybe provided to the officer than the citizen informant actually gave, or he didn't get the full story or something. So it's basically imputed to the officer what the 911 call was about, and you look at the 911 call instead of what the officer knew, don't you?
You do if that call is properly admitted, and I guess that's the first issue.
Right.
So assuming, going to the second issue, is assuming for the sake of argument that it was, yes, you're correct. The officer need not be aware of the facts precipitating dispatch, and I think that's in Mommy versus Wisner. You do look to the facts that the dispatcher has, and I guess in this case we're referring to the original dispatcher. There's two dispatchers here.
That's where it gets confusing.
I guess what I'm saying is the information that the trooper had, even if the facts provided by the citizen caller provides reasonable suspicion, that wasn't relayed to the trooper. All the trooper knew was he's looking for a green Ford truck. I guess what I'm saying is he did not have reasonable suspicion that that truck that he stopped was the truck that he's looking for. If all you know, that's what I'm saying.
And I understand that argument, but that's where I'm getting confused, because I know the case law said just exactly what you said. So the usual scenario is, that the trooper has more information and find out that it was really an anonymous source, that there is no reliable informant, for instance. And then even though he had all this good information, they say, well, it wasn't reliable because it was an anonymous informant or something, and there was not the reliability in the actual tip that was given. So it's a different situation. This is where there may have been reliable, sufficient information that was given in the tip from a citizen informant that was not conveyed to the officer, and the officer pulled somebody over. So it seems like you're putting another standard on there. It seems like you're saying it has to be reasonable suspicion from a reliable source to begin with, and also all that information has to be conveyed to the police officer in order for them to have reasonable suspicion to pull over the car.
Well, I don't know that all of it needs to be.
But you have to have at least something.
The
that
officer needs
shows
to know that
reasonable
he's stopping
suspicion.
the right person. I mean, usually, you're right, this is kind of the inverse situation. Usually you're looking at whether the tip was sufficient. In this case, we're looking at whether the officer knew who he was stopping was the right person.
Counsel,
It's kind of a different situation.
just so you know, you were right about it, your rebuttal time now. It's up to you if you want to keep going. I just wanted to let you know, because I told you.
Okay, no, I'll leave it at that. I'll leave my last 3 minutes for rebuttal. Thank you.
Morning again, in your role to the state of Ohio. So although the appellant raised one assignment of error, there are multiple issues broken down in that assignment of error. And I guess I'm to go in order from the brief, unless you have any questions at this point. With respect to the facts precipitating the dispatch, as this court is aware, when an investigative stop is made in sole reliance upon a police dispatch, as is the case in this matter, the state must demonstrate at a suppression hearing that the facts precipitating the dispatch justified the reasonable suspicion of criminal activity. And it was in Wisner that's been mentioned, the Ohio Supreme Court said that a telephone tip by itself can create that reasonable suspicion. And the facts in this case, as the court articulated, was an identified citizen informant, so very reliable. There's no question that original tip created that reasonable suspicion.
Counsel, I'm going to stop you here, just like I had asked appellant's counsel. To me, the problem with this case is it is the inverse of what you usually get. Usually, the dispatch will say, there's a car weaving all over the road, we've been informed, and, they just almost struck a car, and they saw him leaving a bar and all this stuff. And then you find out that this was not somebody that was identified, never heard from the person before, didn't leave their name, didn't leave their license number, nothing like that. And then you look at whether or not that was a reliable source of information so the officer could establish reasonable suspicion. But here, I don't think either side is really disputing that basically the only information given the officer was there was a .19 potential violation in a green truck. So are we to say then it doesn't matter what the officer knew when he pulled over? It's only what the informant said?
And I think that the case law does support the latter statement there. First here, we do know that the facts are confusing as to whether, the testimony was confusing as whether he knew it was green Ford truck. We know that it was a green Ford truck and the possible .19 here. But I think that the ultimate issue is, as you said, that original citizen informant, reasonable suspicion existed, they were highly reliable. That was passed on to the Wayne County Dispatch. When you make that stop, when the stop is based in sole reliance because of the police dispatch, the standard is whether that dispatcher knew or had that reasonable suspicion. Whether the trooper knew or had reasonable suspicion, that's irrelevant. It's about issuing the dispatch where their grounds.
But doesn't the trooper have to at least make an initial determination based on the information relayed to him? He may not know, or she may not know all the facts, but there at least has to be some evaluation that if those facts are the case, if that's what was relayed in a reliable manner, that would give me cause to pull over this individual.
I think that they do have, the trooper does need to be aware of some of those facts, and then the facts in this case support that he was 1 minute and 30 seconds away from that Econo Lodge, that location. He testified that he saw, it was the second vehicle that he saw on the road, the other was a white semi. And the video, you can see that it's a pickup truck. It is at night, and so, but the officer testified that he knew that it was a green Ford truck. And it doesn't have to be that he stopped, he's making an investigatory stop. He doesn't have to get it right when he stops. He's using that reasonable suspicion from the dispatcher, hey, this seems to fit, I'm gonna make a stop. And the facts are actually in dispute throughout the record. Dispatcher Lloyd, with the Ohio City Dispatch, he's saying that at the same time that he's taking the information and radioing out to the responding unit, he's also typing in and entering in the information. And so the facts, the report that they actually had to make the model, the license plate number. It had, I believe, and I'm not going to attempt to quote it, but I believe that when the officer actually pulled over that green Ford truck, then he said, confirm HAA, whatever the license plate was. And so confirmed kind of implies he believed in his testimony that he had known the license plate, but he couldn't state for sure. That would seem to support his position, but it ultimately goes back to that reasonable suspicion needs to come from the dispatch. Although it was Dispatcher Lloyd who ultimately related in this case, his information was one step removed from that the citizen informant, but it was from another dispatcher, a reliable source, and so he's trying to get all the facts through. So I think in this case, that because the information that he had, there was sufficient knowledge, veracity, reliability to provide that reasonable suspicion for the investigatory stop.
Counsel, I needed to go back and read something because it had struck me when I read it the first time. In reading the judge's actual order in this case, the judge says, although it is not clear to the court, even after reviewing the exhibits, the total extent of information Trooper Rondick possessed prior to stopping the defendant's vehicle. And later on, when he talks about totality of the circumstances, he doesn't mention that confirmed license plate issue that we talk about or have read about. Instead, he says, although it would have been preferable for Trooper Rondick to have had available to him all of the original information, including the model of the defendant's vehicle, the license plate, and the specific description of the alleged inebriation. But anyhow, I guess you're asking us to stretch something that the judge didn't even find who heard the evidence.
I'm just trying to, the judge heard all of that evidence, and obviously when he writes his judgment entry, it's, from his notes and what he took away from that. In my review of the transcripts and trying to, find and see what happened at trial, I think that it can be supported from the evidence that was before the trial court that he possibly knew the license plate number because of that statement at trial, confirmed and giving the license plate number. But even if he didn't have that license plate number, as we recognize, it's the second vehicle out on the road. It's a minute and 30 seconds away from the O'Connor Lodge. He won't have a direct location, but he's headed towards the city of Worcester, and he makes the investigatory stop, and he was warranted in doing so as the state's position with respect to the facts precipitating the dispatch. With regard to the authentication of the 911 call, I believe that the Weisner case completely addresses the issue as basically at a suppression hearing. It's not that the rules of evidence necessarily don't apply, but the court may consider hearsay evidence at a suppression hearing, may consider evidence that would otherwise not be admissible at trial. I've reviewed the Edwards case that appellant's counsel also cites to, and that case also cites back to Weisner for that same proposition that at suppression, it's proper for the trial court to review, or to consider hearsay evidence and evidence that otherwise would not be admissible. Also in the appellant's brief, he cites to State v. Kerr, which is the second district case, kind of talking about the requirements and how a 911 call would be authenticated. I wanted to point out that that is actually a case that's at trial. It's not at a suppression hearing. So, of course, you do need to take those additional steps at trial, but it wouldn't. That would not apply at the suppression hearing, and it wouldn't be proper to go forward. And also in Weisner, the Ohio Supreme Court found error because it determined the lower court should have considered that the hearsay statements relayed to the officer in assessing whether the facts known to the dispatch were sufficient to justify a stop. So I think it's proper to have played that 911 recording, and so that the court can use that and assess, okay, that's a identified citizen informant, here's all the information they gave, it rises to the level of that reasonable suspicion. With respect to appellant's third error, with sufficiency of the evidence to sustain reasonable suspicion, Mr. Goins argued that the state was required to present evidence of the facts precipitating dispatch. Again, the state did so. The facts were demonstrated through the testimony of Trooper Onduk, Dispatcher Lloyd from the Ohio State Patrol, as well as the citizen informant's 911 call. Even absent that 911 call, however, just Trooper Onduk and Dispatcher Lloyd's testimony and the credibility of it coming from dispatch itself, I think that it's factored in, and there was sufficient evidence on that issue of the finding of reasonable suspicion. And lastly, with respect to reasonable suspicion to make that investigatory stop, I think that this court already had pointed out, Trooper Onduk did not need to have his own reasonable suspicion. The Weisner court supports that. It was if dispatch had that reasonable suspicion to issue the dispatch. And even the trial court in its judgment entry noted there's no question that had all of this been relayed from this identified citizen informant that there's reasonable suspicion. The question becomes under the totality of the circumstances, did each dispatch basically, issue on enough to give Trooper Onduk that reasonable suspicion? But I would note again that it ultimately doesn't factor down to Trooper Onduk's reasonable suspicion. It's the dispatch. And again, Wayne County Dispatch was a reliable informant to Dispatcher Lloyd. And at a minimum, we know from the evidence that Trooper Onduk was advised to be on the lookout for that green Ford truck that had left the O'Connor Lodge, was driving towards the city of Worcester, was a possible .19, and explained what that possible .19 meant, 45-11-19, and being an intoxicated driver. So dispatch had that reasonable suspicion to issue the dispatch, and Mr. Trooper Onduk did not need to have his own. Essentially, the finding of reasonable suspicion overall is based on the totality of the circumstances from the time the citizen informant called Wayne County Dispatch to the time Mr. Goins was stopped. The trial court found that was approximately 10 minutes. Further, the trial court determined that Trooper Onduk's dash cam video located Mr. Goins in his green Ford truck approximately 1 minute and 3 seconds away from the O'Connor Lodge. So given all of the foregoing under the totality of the circumstances, trial court properly determined that Trooper Rundick and the dispatch had that reasonable suspicion to make the investigatory stop. There's no
Thank you.
questions.
Thank you.
Thank you.
You'll have 3 minutes and 22 seconds.
Thank you, Your Honor. I want to start by addressing this issue about whether Trooper Ondick had the license plate number prior to stopping Mr. Goins. To me, this should not be in dispute. If you look at page 13 of the suppression transcript, Dispatcher Lloyd said the only call that I had with the Wayne County Sheriff's Office is the one that we heard there in court. It is undisputed that the license plate number was not included in that call.
Even if it wasn't, it was like 1:30 in the morning, and in the amount of time, the 10, 15 minutes so that this all happened, Trooper Ondick only encountered one other vehicle, and it was a white semi-truck, right? So this is the only vehicle he's seen at all, and he knew it was a green Ford truck. And you had mentioned it could have been any green Ford truck, but there's only one out there. So how does that factor into whether we knew the license plate or not?
Well, there was only one, other than the semi, this was the first call he saw. I mean, there could have been. First vehicle he saw, there could have been 10 other green Ford trucks on the road, we don't know. I mean, and that's why I bring back to the point where I made. He saw the vehicle and pulled it over within 2 seconds. And the only information he had at that point was he's looking for a green Ford truck.
But he knew a .19 too, right? He knew that as well, didn't he?
Well, he did know that, but I guess what I'm saying is I'm not saying that Trooper Ondick had to have independent reasonable suspicion about dispatch. I'm saying he has to know that he's getting the right vehicle so that an innocent party doesn't get stopped. The only information he knew was that he's looking for a green Ford truck somewhere in Worcester coming from the Econo Lodge, which, like I said, there's 20 or 30 directions you can go from the Econo Lodge. He didn't have the license plate, he didn't have the shade of green, he didn't have the model of the car, what kind of truck it was, a description of the driver, he had none of that. What I'm saying is he did not have sufficient information to know that the vehicle he was stopping was the right one. And that's the only point I wanted to make on that. Thank you.
Yes, okay, thank you. All right, thank you both for your presentations. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on our website and that of the Supreme Court.